Distinguished ladies and gentlemen, Your Excellencies, my lords, we're moving now to a very, very important part of this program, which is the keynote speech. I'll be inviting our keynote speaker, and when he gets here, a citation will be played. All right, so we'll take the recorded version of his citation. Please go ahead.
Professor YEMI OSINBAJO, SAN GCON, was born on March 8, 1957 in Lagos, Nigeria. He is a distinguished lawyer, academic, public servant who served as the 14th Vice President of Nigeria from 2015 to 2023. He obtained his law degree LLB from the University of Lagos in 1978 and was called to the Nigerian bar in 1979. He later earned a master's degree from the London School of Economics and Political Science LSE in 1980. As Senior Advocate of Nigeria since 2002, OSINBAJO has had an illustrious career as a legal practitioner, academic, and public servant. He was a professor of law and head of the Public Law Department at the University of Lagos and served as a member of the United Nations International Law Commission from 1991 to 1999. As Attorney General and Commissioner for Justice in Lagos State, 1999 to 2007, he spearheaded landmark judicial reforms that modernized the legal system, ensuring greater efficiency and access to justice. He also co-founded the Convention on Business Integrity and played a key role in legal advocacy through his law firm, Simmons Cooper Partners. In 2015, he was elected as the 14th Vice President of Nigeria, serving under President Muhammadu Buhari until 2023. During his tenure as Vice President, he briefly served as acting president on multiple occasions where he took decisive actions on governance, security, and economic issues. Since leaving office, Professor OSINBAJO has continued to be a leading voice on global issues, particularly in energy transition and climate change. He currently serves as Global Advisor to the Global Energy Alliance for People and Planet, GEP, and Board Chairman of the Climate Action Platform for Africa, CAP-A. He remains committed to promoting sustainable development, innovation, and good governance in Africa and beyond. He is also a recipient of several awards. He is happily married to his wife, Dolapo, and they are blessed with children and grandchildren.
Distinguished ladies and gentlemen, with a warm round of applause, let's please receive our keynote speaker. On this occasion, the immediate past Vice President of the Federal Republic of Nigeria. Let the applause be better. Thank you.
Thank you very much. Please sit. Your Excellency, the Governor of Bayelsa State in absentia, Senator Duyodire, the Chair of the Plenary, the Honorable Justice Peter O. Afen, Justice of the Court of Appeal, the Honorable Chief Judge of Bayelsa State, the Honorable Justice Matilda Abrakasa Ayemie, my Lords of the High Court of Bayelsa State, and the President of the Customary Court of Appeal of Bayelsa State, the Honorable Attorney General and Commissioner for Justice, Bayelsa State, the Honorable Biri Damo, Senior Advocate of Nigeria, Honorable Magistrates and Chairpersons of Customary Courts present, the Chair of the MBA Yenogwa branch, my dear brother, Mr. Peter Somina Jumbo, and other members of the executive of the Bayelsa Bar Association, and the chair and executive members also of the Sagbama branch of the MBA, the Director of Legal Services of the NCDMB, Mr. Naboth Onyeso, my learned brothers of the Silk, colleagues at the bar, distinguished guests, ladies and gentlemen. Let me begin by thanking the chair of the Bayelsa Bar Association, my dear brother, Mr. Somina Jombu, and his team for the very kind invitation to give these keynote remarks, and also for the very generous hospitality that they have provided us since we got here yesterday. I will always feel at home here in Yenagoa because I know that I have many brothers and many sisters here. As you've heard, Her Ladyship, the Chief Judge of this state, has already disclosed that she and I are childhood friends, and my lady also pointed out that I knew her since she was 11 years old. Just a point of correction, I think she was probably 9 years old when I knew her. And I also have a friend and brother here, of course, His Excellency the Governor of this great state. He's indeed a worthy friend. As you know, he belongs to that other party. I'm sure you know who that party is. But nevertheless, he has been a very, very close brother of mine. He traveled all the way to Ikene, my hometown, when the people of my hometown welcomed me home in July of 2023 after my period of service. And I always will remember him because of that journey that he made all the way, you know. Of course, you know that you only know your good friends when you're out of office, you know. And this gentleman has shown that he's a good friend. So all of you, my good friends, who have not been in touch with me since I got out of office, let me just tell you that no condition is permanent. I'm also very much at home here because I'm the company of my learned brothers and sisters, men and women with whom I've traveled along the same pathway, many for so many years. I'm also in the company of our law teachers, co-travelers with me in the voyage of instructing and inspiring generations of lawyers. I've seen a few of my former colleagues, in fact, a former colleague also when I was Attorney General. And it's because I am so at home here that I've chosen a topic that I hope will open up discussions on where we are in our journey as professionals and where we ought to be. I'll be speaking on a subtext of the theme of this conference, and that is the legal profession, a vision for a new era. The legal profession, a vision for a new era. Our profession is in a radically new dispensation, a dispensation created largely by the most consequential advances in technology and in perhaps the most turbulent and uncertain times in living memory. The problem is that it is not easy to recognize a new era when you are living in it. In 1987, I wrote a seminar paper on computer-generated evidence. At the time, nobody had computers, and there were no mobile phones, let alone text messages. There was no internet. As far as most of us were concerned then, the computer was at best a glorified typewriter. But I had a shocking, eye-opening experience that year, the year that I wrote that article, and that was really the reason why I wrote the article. It was at the library of the Institute of Advanced Legal Studies in London, which I visited at the time every year for research. I got there in December of 1986, and I wanted to find books in the regular catalog, you know, the catalogs that were arranged with index cards and all that, in alphabetical order. I was confronted with a device, a tabletop computer. There were no more paper catalogs. Everything was supposed to be there inside the computer. I had no idea how to use this device, And one of the library assistants, sensing my difficulty, called a student who was on internship to help me out. I discovered that I could locate any book in the library by simply typing the author or the subject and using the search option. I then was able to finally figure my way out, find the books that I needed to use in the library. I knew at that point that the world of research had changed for good, and that this thing called the computer was going to change practically everything around us, including the vital aspects of my own subject area, the law of evidence. So this was what inspired that seminar paper, which later became an article. The chair of the seminar was my mentor and the leading authority on the law of evidence at the time, Justice Akinola Aguda of blessed memory. In that paper, I was considering the then Section 90 of the Evidence Act, that's the old Evidence Act, on documentary hearsay. And I made the point that in the light of the use of computers, the definition of document had become obsolete, and we would need a new definition of document in the Evidence Act. And that we'll also have to reconsider the definitions of original and secondary evidence. The definition of document in the Act at that time, just to cut a long story short, was simply an inscription in letters, figures, or marks on a substance. An inscription in letters, figures, or marks on a substance. Now, this definition could only cover physical, visibly perceptible inscriptions. In other words, all that the document covered at the time was something that you could see written on some kind of substance, usually paper or some other tangible material. Whereas the content stored in the computer's memory or chips is not visible or readable by human senses because it is stored electronically, and one would need a device to decode and display it. I was at the time at that seminar roundly criticized as crying wolf. My critics argued that the definition of a document had lasted several decades, and it would withstand any technological development, including this thing called the computer, which at the time, as I said, none of us in the room had used or had seen. So, because we had no appreciation of how game-changing that simple device would be, we didn't think that any changes should come, or they didn't think any changes should come to our law. Today, as we all know, the definition of document in the new law, in the 2011 Act, is no longer an inscription on a paper or tangible surface. It now covers electronic records, digital storage media, and electronic communications. But all that was 35 years ago. The world of 35 years ago is completely unrecognizable today. Let me make another prediction. With generative artificial intelligence or generative AI, we have verified and how they're attributed. Now, this is just one aspect of what generative AI or these new technologies will do to our law. Just one aspect, just one definition, and there are so many that will change. The pace of technological advancement today, the rise of globalization, the democratization of information has already transformed every profession. Yet, the legal profession, we are bound by precedent and tradition, and of course some bad habits also, has remained stubbornly resistant to change. But our profession needs a new vision, a new set of tools for a new era, and that is so whether we like it or not. We're in a vastly different era from when the tools that we use today were designed. And let me begin with legal education, the impact of technology on legal education. And that means, of course, what we teach and how we teach our law students. But before I do so, I'll attempt to describe what legal practice is already looking like today and what it will look like in the next few years, very, very few short years, maybe 2 to 5 years. and then, of course, I'll then try and prescribe what sort of legal education we need. I was speaking to the new management of the law firm which I co-founded and from which I retired in 2015, Simmons Cooper Partners. And they were showing me their new AI-driven tools for the work of the firm. They now have a ChatGPT interface that within minutes can sift through several legal databases and offer summarized opinions on statute and case law. They also use a predictive analytics and legal strategy interface that uses historical data on case law and statute to provide advice to clients. So what used to take days of research can be done practically in minutes, and the system can argue with you if you oppose its point of view. They also have a tool called the GitHub Copilot for legal drafting. It uses the firm's own database, that's all our own material, and can suggest language and clauses that are tailored to specific legal documents. They showed me yet another tool. This is a work product character recognition tool. And this ensures that all work generated by the system, all documentation that's coming out of the firm, adheres to the firm's professional tone and branding guidelines. And then they also have AI chatbots that make immediate responses to common inquiries from clients. And this works even when the office is closed for business. There are also AI contract review tools like Luminance, Kira Systems, or Spellbook. Now, these ones can highlight risky clauses. They can tell you, looking at a document, that this clause is going to be very risky and give you the reasons why. They can compare clauses in your agreement to existing precedents. In other words, it can tell you this clause has been decided in several courts, not just locally, but internationally, and what the outcome was. They can also translate any kind of legalese into plain English. And these tools are getting smarter every day. In December 2024, just last year, ChatGPT launched its new 01 preview designed to solve complex problems by spending more time thinking. So these systems are thinking for longer now, and so they're able to solve even more complex problems. And the incredible thing about these systems is that they are capable of critical thinking, using huge data resources faster than the human mind. Even judges can now literally use these systems to write judgments. So these tools will literally take facts, evidence, and submissions of counsel, and then let the tools do the application of case law and statutes to the facts and evidence, analyze the submissions, and come to conclusions, write the entire judgment or rulings, including all the orders that are necessary. That is the state of these tools today. So it's clear that a lot of the work that lawyers can do now, or that lawyers used to do, can now be done much faster and much more accurately by technology. The systems don't get tired, they don't go on leave, they don't ask for extra pay, So these tools are becoming, as I said, cheaper and cheaper. And like mobile phones, they'll be available everywhere and to everyone very soon. The laws we practice, the tools that we rely on, the institutions were largely conceived in a pre-digital, pre-AI, pre-globalized world. 30 years ago, lawyers were gatekeepers of specialized knowledge. In fact, 5 years ago, before AI in 2022, lawyers were the sole gatekeepers of legal knowledge, because we were the only ones who knew what to look for in a law library and how to apply the cases and statutes that we find to the problems that our clients brought to us. Now with AI, you don't need to go to a law library or to know what books to look for. You only need to pose the problem to your AI tool, and it will go into the library by itself, search out all the right cases and materials faster than any human can do, and give you an opinion in minutes. So the role of the lawyer is also changing very rapidly. You can no longer be a technistic lawyer who says Section 2 says, Section 4 says kind of lawyer, and survive in the next few years. For example, the commercial lawyer today must be a man or woman of affairs, a global professional with an understanding of how the global financial industrial complex works. He must, in fact, be able to put deals together and not just be an advisor. This is because, as we have seen, technology is fast replacing basic legal analysis and opinion writing. A big part of our cake has been bitten off by technology, and more will be eaten up very soon and very quickly. Years ago, you could make money from writing a learned opinion on doing business in Nigeria. Today, your client can do that himself or herself using any of the AI tools. Besides, globalization has made legal expertise easily available in real time anywhere. What is happening now before our very eyes is the most profound revolution that our profession has ever experienced. A revolution that will radically change the delivery of legal services and even adjudication forever. We are no longer the gatekeepers and custodians of basic legal knowledge. That is all gone. But more importantly, we are no longer the custodians of legal reasoning and legal opinions. So how and what should we be doing now, and how should we be teaching law students now? We now have what we should be looking at now is an enhanced curriculum for legal training. We simply have to change the curriculum for legal training. If students who are coming out of law school, who are coming out of our faculties of law and law school, are to be any use and to be competitive in the years to come. Aside from teaching core legal subjects, we must also integrate legal technology and AI into the curriculum, learning how to critically assess inputs from systems like ChatGPT, like Harvey or CaseText, some of these very common AI tools that are in use now. We need to have more cross-disciplinary training for lawyers, law, data science, and design thinking. Law students and lawyers must now learn about data privacy. We must learn about algorithmic bias and the design of legal tech systems. We must also integrate skills in computational thinking and logic into our legal education curriculum. And because AI systems will increasingly take over tasks like legal research, like drafting, and even basic reasoning, the true value of the human lawyer will no longer lie in our ability to find the law or to summarize it. Machines can already do that faster and more accurately. Instead, lawyers must now focus on the aspects of legal practice that machines cannot replicate, or at least are not able to replicate yet, certainly not with the same nuance or the same responsibility. So we must now develop skills in determining what ought to be done in the client's best interest, ethical reasoning, and interpretation skills. From the point of view of teaching methods, we need to adopt simulation-based learning. And this is in use now in several law schools in different parts of the world. For example, mock AI-assisted litigation or contract review. As I said, the tools can now review contracts. The tools can give you accurate advice on what sort of contracts you'll be signing and the clauses and all that. So we now need to be able to assess what exactly the AI tools are doing. So the training of lawyers must now meet these new realities. We must now train lawyers to work with these tools and interrogate the tools for maximum results. We must train lawyers to ask critical questions from generative AI. Legal education must now emphasize problem solving and critical thinking. Law teachers must also embrace change. It's incredible today that a law teacher is still dictating notes with all the resources available to students. It's a waste of time for a law teacher to have some notes now. I'm dictating, complete waste of time. Why? Because all of this information, any type of information, even in note form, can be done now by generative AI. In other words, I can take all of a textbook and say, just give me a short form of this, or just give me the key points. So I don't need anybody dictating notes. And all of the resources available to students are now available on phones and other devices. Whole libraries can be stored. All the volumes in the Elias Library in Unilag that I used as a student and a lecturer, and more, are now in this simple device here. And I'm sure that in many, many smartphones, you can simply put all of those material on that. I also have a law pavilion, a local electronic database, as I'm sure many of our lawyers and judges here have. It has all the Nigerian law reports and legislation. The platform now also has an AI legal assistant that is designed to help lawyers navigate civil procedural rules and navigate all sorts of complex problems. Most judges and many lawyers and law firms already subscribe to these digital legal platforms or several others. Teachers all over the world today, not just law teachers, are battling with what to do with students who are using AI to write essays, to write academic papers, to write PhD theses, to write LLM theses. And these systems are becoming so intelligent and so sophisticated that it's difficult to tell that somebody used AI to generate a particular text. It's becoming more and more difficult to tell. So, in fact, some universities now are investing in reliable detection methods. So what some universities are doing is investing in, look, what are the reliable detection methods? Or working on rules for ethical use of generative AI. But it's very unlikely that we can do much about these tools, which was launched, many of these tools were launched only in 2022, barely 3 years ago. And it is by its iterative learning processes becoming smarter and more difficult to detect every day. And this might be when you compare it to how calculators were when we first found calculators. Some of us, when we were in primary school and secondary school, there were no such thing as calculators. But some of the younger ones who are here, obviously, providers who may then use a hybrid format, in person and online, and the exams also may be online. So if I want to teach a student how to move a motion or how to cross-examine a witness, a good video showing how it's done will be more than sufficient. So many learning platforms today have excellent virtual courtrooms where you can learn faster than any teacher can teach you, and it's becoming more and more sophisticated. The virtual platforms, you can virtually participate. You can be in a courtroom, and you can learn from inside a courtroom. Things have changed. We can't insist on the old ways. And it's in my view the case that the days of in-person law school are over. We must embrace online teaching, accessible from anywhere in the world, in addition to licensing, training, or coaching organizations to conduct preparatory training for bar exams. Attachment to chambers, of course, should continue, and we should retain that, while examinations can be online or in person at various centers, locally or abroad. This is what is going on everywhere else in the world, especially in the Commonwealth, where large numbers of students want to train to be lawyers. Nobody is insisting anymore that they must report in Buhari somewhere or report in some other location to be trained in-house. Nobody is insisting on that anymore. We have to find more sophisticated ways of doing the same things much better. Let me speak briefly to the state of our profession. The legal profession in Nigeria, as you know, and the system of administration of justice is perhaps one of the oldest of the professions. It has created reputations, dynasties, enormous wealth, and modest livelihoods for generations. But its integrity, the integrity of our profession, the credibility of our profession, and the relevance of our profession are gravely threatened, and has been so for so many years. There is no doubt that there is a grave decline in the prestige and importance of our profession. There is, at least anecdotally, a sense that our profession is crumbling under the weight of corruption, ethical violations, and poor standards. The stories of counsel, senior and junior alike, acting as conduits for the giving of bribes to judicial personnel is rife. It is worse, of course, when such are senior counsel. As I said, a lot of the evidence is anecdotal. But the problem with reputation is that it is damaged by mere perception. In this case, a perception that our system of justice is corrupt and that the bar and the bench are culpable is enough damage. Just the perception is enough damage. We're already hearing people say, better to know the judge than the law. Once your clients and our clients get to the point where they believe that justice can be bought or influenced, you no longer need good lawyers. You don't even need lawyers. All you need are middlemen. All you need are transactional middlemen. There are, admittedly, and I must say that, and we must admit that there are very many reasons why we should uphold the integrity of our craft, why we should uphold the integrity of our profession. A thriving legal system that is rooted in credibility creates greater opportunities and wealth for all its practitioners. Also, the competition amongst countries for foreign investment is getting fiercer by the day. But nobody wants to invest in a country that has a reputation as a corrupt judicial destination. But there are higher reasons also, even altruistic reasons, timeless reasons. If we are to be more than mere beneficiaries of legacy, we must become its authors. We must leave behind a profession that continues to confer honor, dignity, and livelihood to generations who we will never meet. To do so, we must regulate ourselves. We must enforce discipline, not merely to punish, but to protect the patrimony. Creating and maintaining efficient disciplinary structures and rules is a huge challenge. But in the end, the difference between the elite who build enduring legacies and those who squander them is not brilliance or ambition. It is the capacity for self-restraint, the willingness to sacrifice personal comfort for collective good, and the seriousness with which they honor the obligations that privilege confers. If you look at the British legal establishment, for example, it stands out as the exemplar in self-preservation and also preservation of the Commonwealth by the recognition of the obligations of privilege. The British legal system has just recognized from time immemorial that we must protect this thing called the legal profession because it confers so much prestige and wealth for those who come into it. And they do so by strict enforcement of entry into the profession and also strict rules of entry to the preferment to the rank of Queen's Counsel